It is now 1:58. Court will start in approximately 2 minutes.
All rise. Justices of the Appellate Division, Supreme Court, First Department. Be ye all representatives of the Appellate Division. Draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon, everyone. Welcome to the Appellate Division First Department. I am going to call the calendar. You are all familiar with the process. Please only request the time that you think you need in order to argue, not what would be, given in a perfect world, since this is not a perfect world. And just keep in mind that we've read your briefs. We're familiar with your arguments, okay? People versus Monet Davis. You weren't listening, were you? Yes, sir. Yeah. 5 and 2 and 5. Phillips versus Murtha. Yeah. 6 and 2 and 5. Concordance Healthcare versus Corey Capital. 6, 2 and 6. People versus Francisco Vega Vasquez. 5, 1 and 5. Amenziani versus Subramaniam. 6, 2 and 6. People versus Freddie Jackson. That matter is submitted. South Shore versus First Class. 6, 2 and 5. Board of Managers versus People's Foreign. I think you're in video.
Yes.
Hi.
For the appellant, hello, good afternoon. For the appellant, 5 minutes and 5 minutes for rebuttal.
5, 1 and 5. That case is going to be called first, by the way.
Thank you.
Konstanowka versus Caring Professionals. Submitted. Wilder versus Frenesis Medical Care. Submitted. As I stated, the first case to be argued will be Board of Managers versus People's Foreign. Where'd she go? Uh-oh. Oh, there she goes. I'm scared.
Oh, I'm sorry.
1 second. Just let the respondent get seated and settled. Okay, you may proceed.
Good afternoon. My name is Nancy Duran with Smith, Wesson Jacobs on behalf of the appellant, Alandalus Properties Court, formerly known as People's Foreign Exchange Corp. And the crux of our appeal hinders on basically defendants seeking the day in court that it was promised from a prior order of the court. The court decided prior summary judgment motion on August 20th, directing certain key factual points to a referee to be further fleshed out. No hearing occurred, although the parties did exchange certain accounting documentation. And then this February 10,
Counsel,
2022.
this is Judge
Yes.
Mendez. Didn't the parties agree that the court could decide the matter on submission on November 19, 2020?
No, the parties, the defendant specifically at the time, and I believe that was through prior counsel, had reserved its rights. They agreed to exchange the information of the accounting. They never agreed to reserve the issue of attorney's fees for the court. The expectation was always that, especially on the issue of attorney's fees, that would be directed by a referee, because there was a lot of uncertainty. There was a portion of the attorney's fees that were for work that were clearly, not for items that had been rejected by the court.
So, Counselor,
regarding retroactive application.
Counselor, at some point in time, did the court state that they were going to make a determination on the papers based upon submissions from the parties as to the monies owed, including the attorney's fees?
No, there was never any such notice given to the parties of that fact.
So why then did the parties submit the redacted form for the attorney's fees?
I believe there was a matter of discovery to be exchanged, but the redaction was actually a big issue because there were items redacted that expected to be fleshed out at hearing. At no point did the defendants ever understand that there would not be a hearing. Even the referee assigned didn't put in a decision in order on the reference till well after the February 22 order had put in. There was always an expectation in the case that matters would be submitted to the special referee. In this case, I believe it was Diego Santiago.
So once the court rendered a decision as to the attorney's fees, why was there not, or was there some type of motion to re-argue or to re-argue?
Well, at that time, I can't answer that question as to why there was no motion to re-argue, but when my firm was brought in around that time, we immediately put in a notice of appeal of the February decision.
Are you
Go ahead.
Are you familiar with a letter from November of 2020 which appears on its face to constitute an agreement, as Justice Mendez said, that that the issue could be submitted on papers?
I am not.
Well, you weren't counsel at the time, right? That you weren't counsel at the time. That was prior counsel, correct? You're coming in after the fact. Is that correct?
That is correct.
So you don't know, we don't have anything. I mean, there's a lot that went on that you're not sure of what actually transpired.
Well, we are. I wouldn't necessarily put it that way, Your Honor, because there are a number of documents that were filed and exchanged by the parties in a record. I believe there was a hearing on the record where, we made note of what was represented, what prior counsel represented at that hearing, and prior counsel never conceded defendants' right to the reference that was directed from the August 2020 order. I'm sorry, this November 2020 letter that you reference is, I apologize for directing a question to the court, but is that in the record?
November 20th, there was a court conference on November 19th, 2020.
Here it is, I am. Yeah, can I read to you from the record of that conference wherein the parties discussed taking the matter on submission?
That's November 19,
November 9th.
2020.
Yes.
What's the page?
This is on page
Record,
847.
Say it again?
Record 847 and 848.
right, and also record 841 to 858. And so at that conference, apparently, defense counsel stated that in the event the court decides that this should be taken on submission, there are certain factual and legal issues that need to be more fully briefed. The court then directed the parties to exchange the relevant documents and then put in your papers on summation. And that's record 848.
Yeah, that was it. And Mr. Bernstein, that represents the defendant, says, that sounds fine, Your Honor. So there was never an objection to having the matter decided on submissions.
I read that a little differently. I'm unable to locate that in the record, but I recall that portion of the transcript from my reading in preparation of the reply. And what I recall specifically is that the idea thrown out that, but the sounds good that I read from the transcript from defendant's counsel to me was not a waiver of,
So counsel,
the right to.
so counsel, the way to remedy that, because you weren't there, we weren't there, is to get counsel who was there to give an affirmation to explain that. Because at this point, it's your reading and our reading, and it sounds like that there's a waiver or at least some sort of concession that, okay, we'll let the court decide on papers. You weren't there. I mean, you came in after the fact. So, you know, there's a little bit of a, you know, problem there, I think.
Although I see it a little differently, Your Honor, and I
Okay.
apologize because I can't see all of you, so I do apologize. It's a little different for me.
Okay.
But if it were properly before the court and there was no motion pending before the court when this February decision came out, it would be a lot easier to be able to point to documents that should appropriately be in a record to challenge that particular motion. So there was no motion, for example, to determine what the appropriate common charges or attorney's fees would be for the court to decide. And so the appeal was a little challenging because we're stuck with an order with really the documents here were really relevant to the August 20 order because the February 22 order gives us no point of reference.
Well, counsel, if you take that position, that there was no motion, that this wasn't decided on a motion, it's not an appealable paper then. Then you have to move to vacate it and get a decision and then appeal from that. If you're arguing now, if I understand it, is that there was no motion and the court just went ahead and did this and decided something that there were no papers for, my understanding is that's not an appealable order. You need to now move to vacate that order, or like as my colleague said, move to re-argue, and then from there you can move to renew, however you want to look at
So
it.
counsel, you can ponder that question and respond on your rebuttal.
Thank you, Your Honor. I'm assuming, Your Honor, that means that my time is up and I should.
Yeah, you have time on rebuttal, and I'll let you know.
Right.
Your adversary is going to argue it now, and then you'll have your time on rebuttal.
Thank you.
May it please the court, good afternoon. My name is Morgan Manley, and I'm from Smith, Gambrell, and Russell, and we represent the respondent, Academy House Condominium. I want to pick up where Judge Mendez left off.
Well, yeah, if you could, can you shed some light on exactly what occurred?
Yes, so the parties agreed to a procedure because at the time it was in the middle of the pandemic, and there were no references being made. There were no JHOs available. And so what happened—
Well, your adversary mentioned, I think his name is Diego something. But anyhow, she mentioned a name, who was the referee.
So there were no referees available at that time. What happened is far after the fact, after the court decided, then all of a sudden the parties were contacted by the referee. Of course, that contact is not in the record, but that is what happened, and we explained.
And this was after Supreme Court had rendered a decision?
Correct.
So was there a discussion in that November 19, 2020 conference? Was it decided at that point in time that the determination was going to be on papers and everyone was to submit?
So the idea was that the court would see the submissions, and this is, as Judge Mendez and Judge Oing pointed out on 848 lines 4 through 15, that the court would see the submissions and, if necessary, hold a hearing if it was necessary. But that, even if the court were to say, okay, there was no agreement that there was going to be heard on just the papers, it is First Department law in the cases that we cite, both Mendez and Airtight Manufacturing, when there's no specific arguments that are made, no circumscribed challenges to the accounting or the fees, then there need not be a hearing if there's no factual issue warranting it. And here there wasn't one. Well,
I think the argument is perhaps there wasn't one because they were unaware that those arguments were not going to be heard by the referee, but rather the arguments were going to be heard by the judge.
I would refer, Your Honor, to 797 of the record, where the prior counsel directly references the reference back to the court that he had made the decision to take it back. So yes, we can't rewrite history, and no, the current counsel wasn't here, but they are bound to what the prior counsel of appellant agreed to, and they agreed to have the court decide it. And that's clear, not just from that, but also from the parties' memorialization of the agreement on page 1016, which was a letter to the court, and finally, also on 1030 of the record is the respondent's request to have this decided because mediation had blown up, because the court had referred it to a mediator. So I think there is plenty in the record to suggest, if not affirmatively state, that the court had taken it back. He was going to hear it he was going to take it on submission unless there was a hearing necessary.
So how could the court make a determination? Well, my understanding is that the submission was in a redacted form, right? In terms of the dollar amounts and the basis for those dollar amounts. So if they're redacted, how would the other side be able to make a determination as to whether a dollar amount was reasonable or unreasonable? And I think that the agreement states that the attorney's fees have to be reasonable.
So absolutely, the attorney's fees have to be reasonable, but the amounts weren't redacted. What was and nor were the entire portions of what was being charged or what was being done. It was just what was necessary to protect client confidentiality and privilege. And the only issue that they said we can't figure out what is going on in these was the issue with respect to the retroactive charges from pre-August 2017. But if you will look in the record at page 1012, which is one of the invoices, there's specific references to prior charges and retroactive charges, so they could see that, but they didn't bring that up. I'm bringing that up. Moreover, that's not the type of thing that can be separated. The central claim, may I finish my thoughts?
Yes, please.
The central claim here was the 13% common charge. That was the entire argument. And you can't separate, there was no separate claim for a pre-August 2017 amount. And it wasn't the type of thing under Hernandez, which they cite, that you could separate and subtract from the claim. So unless the court has further questions, I'll
Mr.
rest.
Shulman, did you have another question?
The issue of the 13% isn't their issue here, though. In other words, basically, even you agreed to waive the charges pre-August 2017, correct?
We agreed,
In the
yes.
end of the day.
That's correct, we did. We did.
In the end, and they were given all the paperwork underlying the 13% charge.
They were, correct.
So no surprises there.
No surprise.
So the whole focus here, as I see it, or from their point of view, is, and I'm rounding off the numbers, is it reasonable to charge about $105,000 for about $45,000 worth of maintenance charges, correct?
So that
Which is basically double it, more or less.
Correct. So they raised below the fact that there was, and I think this is where Your Honor is going, is that there was separation between, or there was more fees than there were the amount warranted. But I would just point out two things. One, we argued below in Clark and Board of Managers of 55 condominium that just because the attorney's fees are more than the amount awarded doesn't mean you have to reduce them. And number two, our award amount was not just the quantum of damages, but also the fact that we could charge the 13% from August 2017 into the future indefinitely.
So you ultimately got what you sought,
Correct.
which supports that you're a prevailing party.
Correct.
Contrary to all the legal argument that they had a full and fair opportunity to bring to the judge.
And the judge found specifically in its February 2022 order that it had previously held that we were the prevailing party. Even if he hadn't, there certainly is a basis for that here.
Did they ever raise any comparison of the amount of their attorney's fees versus your client's attorney's fees?
No, they did not.
And let me ask you this question. If you hadn't waived those damages pre-August 2017, do you know how much you would have gotten in an award if you were awarded that?
It was an additional $10,000. It was not a significant amount.
Thank you.
Thank you.
Thank you very much. So you have time on rebuttal?
Yes, ma'am. And I just wanted to bring out a couple of points. It seems to me that Counselor conceded that in 22, when the discussions were had at hearing regarding whether or not there would be a hearing or whether or not the parties would rely on the court to make a determination, that there was always an expectation that a hearing would be held if necessary. With respect to the document at record,
the question is what
790.
Excuse me, counsel. The question is this is Justice Gesmer. The question is what would have rendered it necessary given the conversation that was had on the record in November 2020.
And so what we don't know is what led to the court to make this, again, what I perceive as the February 2022 order out of the blue. But with respect to what the parties' expectations were, in light of the fact that there was no agreement at that point that there would absolutely not be a hearing, the fact that a referee was substantively assigned, and the fact that in 2021, based on that letter from the prior counsel of defendants in this case that counselor pointed to at record 797, the document was sent, again, and I quote, in advance of a potential hearing on the relevant issues. And that's from prior counsel, suggesting that there was always an expectation of an impending hearing.
Counsel, I'm sorry, this is Judge Shulman. It's been my experience, and I know it somewhat dehors the record, but having historically dealt with commercial landlord-tenant matters, it was not unusual for a court to sui sponte in conferencing a matter, say, hey, folks, how do you feel about submissions if everyone understands what's being sought? And here, everyone agreed to exchange the accounting And as we just heard from your adversary, the bills, while redacted in terms of privilege matter, did break down the hourly rates for partners, associates, et cetera, maybe leaving out the name as to the nature of the conference, wrote motion on blank, whatever it is, although wrote motion, but left that part blank, as you understand what I'm saying. That's not so unusual. In terms of case management, how do you, since you were not there, how do you not
Well,
understand
but
that?
that's not exactly
Just,
what
Counsel,
happened.
just let me finish the thought for a second.
Oh, sure.
One of the
My
key
apologies.
points that led to the judge making this decision was the fact that there was monies owed to the condominium. Attorney's fees were growing, and they weren't getting the hearing right away. The pandemic was affecting everyone. They're looking for a way to issue resolution. Let's move this along. So the court says, okay, submission. Doesn't that make sense?
Not under these facts, because in fact, there was the difference of what the condo was expecting to be paid and the dispute between what was in the offering plan and bylaws. So there wasn't a matter of zero common charges being paid to the condo. And where there was an expectation of submissions, pre-hearing submissions being held, I don't think it was it would have been expected that the court were to announce that it would not be pursuing, that it would in fact be issuing a decision based on the parties' submissions. That's the step that never was. So at the hearing, the parties agreed to preliminarily submit documents and information on the accounting. They never subsequently agreed to waive their rights. There were issues subsequent to that on improper replies being held, because had the court kind of foreshadowed that I'm just going to rely on what papers were already there and I'm about to render a decision, then the parties could have made their objections and reply points at that point. But they were sort of left without having the opportunity to have a last word on the submissions.
Thank you, counsel. Thank you both.
Thank you.
Take care.
Thank you.
Thank you. Back to the beginning of the calendar, People versus Monet Davis.
Good afternoon, Your Honors, and may it please the Court. My name is Kevin Dunshee for the Rosenberg Law Firm, appearing on behalf of the defendant appellant, Ms. Davis. 5 points in our brief, 2 specifically that I'd like to highlight for the Court, turning first to the weight of the evidence issue. Your Honors, this is a case in which a jury was invited at nearly every turn to speculate and fill in the glaring blanks left by the complete dearth of evidence.
Did you watch the video?
I did, Judge.
I mean, I know it was kind of long, both of them, but I mean, after watching the video, and I'm assuming the jury watched the video as well, what was the speculation as to what occurred?
Well, there was speculative intent and certainly speculation as
Speculative intent? She's pointing in the direction of where her father is shooting, ostensibly at the complainant. She's pointing and telling her father to shoot, and pointing in the direction of the complainant. So again, I'm not under, and then her father, lets off 7 shots. Luckily, he doesn't hit anybody or anything. But where is the speculative intent in that?
Well, I think the most important point to highlight, certainly, Judge, is that the video has no audio. So there are no facts on the record, either from witness testimony or from anything that can actually be gleaned from watching the video itself.
So her body language, her jumping up and down, her continually pointing in the direction that the father, again, lets off 7 shots, we can't discern anything from that.
I think I would have to disagree with the court as to the characterization, which was also made by the people at trial, that Ms. Davis was repeatedly pointing. She did testify on her own behalf
But
That
isn't
was based on the video. I'm sorry.
No, go ahead.
That was based on the video, from what I saw. Maybe, others saw something differently. I can only speak for myself. But what I saw was her continually pointing in that direction.
And wasn't that a reasonable interpretation of the video for the jury to derive that she was, in fact, pointing in the direction that her father ultimately issued his shot, made his 7 shots?
I don't think so, Judge, certainly with not any more testimony regarding what exactly it was that preceded the ultimate shooting. I mean, Ms. Davis testified on her own behalf. She denied.
Can't they consider as the things that preceded that, the emails, the email or text, I've forgotten which it was, that she sent to her son?
The text that she sent to her son, I think, of course, could have been and was considered by the jury. However, I think the crucial determination was whether Ms. Davis was even aware that there was a weapon present at the time that it was ultimately fired.
Let's move beyond the videotape, okay? How about the statement that the victim testified? Is that hearsay or not? Why is that not hearsay? Because that's sort of linking everything together, right? I mean, you can argue about what you saw on video, but his statement was to his mother, I believe, came in, right?
It did come in, Judge, and I think the court erred in admitting that statement as an excited utterance.
He got shot at 7 times, even though there was a little time that passed. I mean, getting shot at.
It was a 30-minute delay.
Yeah.
The mother testified that he was obviously shaken. He was crying because he had just gotten shot at 7 times. And so I think under the stress of the moment, you could say that that there was an exception in terms of it being an excited utterance.
I think, Judge, I would have to disagree in that there were significant intervening events on the record and even testimony from the victim's mother herself indicating that he actually calmed down and she had to make some efforts to calm him down prior to him even uttering this alleged statement. As the court's aware, the standard is whether the intervening events would have allowed Mr. Hayes the reflective capacity essential for fabrication. I think in this case, where everything on the record indicates that he made at least 2 trips, ostensibly by car. It's not really clear from the record whether he walked or took a car, but he did travel from Harlem to the Bronx. I'm assuming he either drove himself or called a cab. But in either scenario, a trip to his son's house first, where his girlfriend at the time is awaiting him, who testified and was present. Presumably there's some conversation between the two of them because the record indicates he didn't leave that area right away. He travels an additional distance from that residence to his mother's home.
Counsel, I'm not aware of any absolute limitation on the discretion of a court to admit something as an excited utterance based on either the passage of time from when the distressing event occurred or the distance the declarant might have traveled between the distressing event and the statement. So it seems to me, I don't understand why this ruling wouldn't be within the trial court's discretion after hearing all of the testimony.
I think certainly, Judge, it's a case-by-case analysis.
Right.
And courts have rightly called into question the validity of the excited utterance exception altogether. But if I may just finish the thought.
Oh, sure, go right ahead.
In this case, I do believe the central question was whether there was a reflective capacity that could have allowed for fabrication. And I believe in light of the passage of time taken in Congress with the fact that he's spoken to multiple people prior to ultimately allegedly uttering this statement to his mother, calls the reliability of the statement itself significantly into question, and the court should have precluded that statement.
Is there any argument that can be made that the statement is even more credible, given the fact that he asked his mother not to call the police, not to say anything to the police, not to report the incident?
I don't know, Judge, only because I
mean, it seems to me that if he's going to fabricate stating that the defendant and her father shot at him, but by the same token, he's going to say to his mother, please don't say anything, don't tell the police, don't report it, because I don't want my son to lose his mother. I'm wondering whether the argument can be made that that even, that shows that the statement is even more credible.
I don't know that I'm arguing, Judge, just to answer your question, that this was a conscious fabrication or that the victim here intentionally lied. I think what the circumstances would have allowed for, however, is a contemplation of the totality of the circumstances, a realization certainly that there was an argument that occurred beforehand in which Ms. Davis admits involvement, admits getting violent with him, and upon that reflection, he has the ability to fabricate, whether consciously or not, her involvement in the instant event, such that it would have made the statement unreliable.
I'm still struggling with your point. As my learned colleague pointed out, the video speaks for itself. You see him at a distance. There's no indication that the video is in any way tampered with. It's authentic. He sees who he's seeing. He sees the father in the wheelchair. He sees Miss Davis there together. Let's say, for the sake of discussion, we're not clear who she was pointing to. She was pointing to trees and not to him. But they were there together. He sees the shots being fired at him. Got to kind of wonder, where would he be fabricating?
I think what the video...
He definitely is not fabricating that Mr. Harper shot at him, correct?
That is undisputed,
That's a
Judge.
given.
And
And he may not have been aware of the handoff of the gun from Terry, I think. The other co-defendant that
there's no evidence that he was.
Well, right, he didn't, but he sees the daughter together with him. He obviously knows she's volatile. They have issues over their son. That's not, where's the fabrication? That's what I'm trying to understand.
I think...
It makes the excited utterance pretty credible, even with the half-hour gap.
My position is that had this statement been uttered in closer proximity to the event, in other words, had the shots rung off and then Mr. Davis makes a statement as to where they came from, it's highly unlikely in my view, or excuse me, that the victim had made a statement as to where they came from. It's highly unlikely in my view that he would have included Ms. Davis as part of those events or having taken part in them, specifically because what the video also shows dispositively is that she's running the other way by the time the first shot rings off. I think it's because he had the ability to reflect on the totality of the circumstances, including the texts that were sent beforehand, including this perhaps unrelated argument that occurred beforehand. That's where the reliability of the statement comes into question, and that's where proximity to the event becomes so important.
Are you suggesting that he couldn't have seen that your client was next to her father?
I'm suggesting that if you're under the stress and excitement caused by an event such as that one, I believe that when what you're seeing and what the video shows is clearly the defendant appellant's father firing the gun, the defendant appellant running in the opposite direction, you running away from the shots being fired by the defendant appellant's father, I hardly think that you're going to implicate her as part of that overall sequence of events.
If you are the victim in this matter, and you are seeing the defendant here pointing repeatedly in your direction, and then afterwards you hear shots fired, and you see shots being fired in your direction, wouldn't it be reasonable for him to have assumed, when he sees his mother and tells her what happened, that she pointed my way and her father shot my way, therefore, she and he both tried to kill me?
I think it calls for a similar degree of speculation as to what was actually uttered by Ms. Davis at the time of the incident, what was actually being said, and certainly characterized.
He's not hearing what she's saying. He's just looking at her, and he sees her pointing in his direction. And after that, as she's pointing in his direction, he hears shots being fired.
And sees the
And he
flashes
runs.
7 times. I mean, I think our problem is you're using the term speculation. I think you're using it in a form that I'm not familiar with. But you have time on rebuttal.
Thank you, Judge.
Good afternoon, Your Honors. May it please the court, Samuel Goldfein on behalf of the people.
So I just wanted to address a different issue. The father, who was the actual shooter,
Yes.
received 3.5. No, 3.5 years. I recognize that he took a plea.
Yes.
Co-defendant, who handed the weapon off to the father, received probation, I think?
Yes, ma'am.
And then the defendant receives 8 years.
That's
so there's a disparity in the sentencing. And again, I recognize that she went to trial, they took a plea. But can you explain why the disparity?
Yes, Your Honor. I think it's for three reasons. First, the other two defendants, as you noted, took pleas. They took pleas to lesser crimes. The minimum sentence here was 5 years for the crime that for attempted second-degree murder that the defendant was convicted of. Second, she was instrumental in this case. The trial judge recognized it, but without her involvement, without her anger, without her pointing.
But she wasn't a shooter.
She wasn't the shooter, absolutely. Harper was the shooter, but without defendant's involvement, she's certainly the only one with motive and intent. Without her involvement, this wouldn't have happened. And the third and the most aggravating factor was the significant instances of perjury that she committed on the stand.
And why is that an appropriate factor for the court to consider at sentencing?
I believe this court and also the federal courts have allowed that perjury on the stand is an appropriate sentencing factor. Here, the defendant lied about material facts. She claimed that the victim approached her with a crowd, that they made threats of violence, that they had a weapon, that she was tapping on her father's shoulder to warn him of the victim's weapon, and that the crowd was fleeing from the victim's weapon as well. I mean, those are all demonstrably false. The video disproves
That crowd was not visible in any of the videos.
I mean, defendant
The crowd was not visible in any of the videos that happened to be going on at that time.
I believe there's no crowd when the victim, Mr. Hayes, approaches the group. The defendant herself says he's alone or with at most one other person when she's viewing the video. So there's no crowd that she's discussing. There's certainly no weapon. There's no display of a weapon. People flee when Eric Harper comes around the corner with a gun on his lap. They go to stand behind him. And just to correct the record a little bit, defendant doesn't flee after the first shot. I mean, that is true, but it's only because the gun doesn't fire the first time. I mean, he raises the gun. He has his arms extended with the gun in front of him. He pulls the trigger. It doesn't fire. But defendant is standing over his shoulder and continues pointing. It's only after he lowers the gun, looks at it, racks the slide, and raises it again that defendant is pulled away by her brother, and then the shots ring off. But it's just moments. So I think the sentence is justified by her instrumental involvement, her perjury on the stand, and the fact that defendants got lesser sentences is reflected by they pled guilty to lesser crimes. As far as the excited utterance is concerned, I think we know that Mr. Hayes was still under the stress of being shot at despite the intervening time and the fact that during his flight he went to pick up his son, both because when he arrives at his mother's house, he's visibly upset. He's distraught, he's crying, he's unable to speak, and when he manages to get words out, the first words are, Monet, the defendant, and her father tried to kill me. And second, as Your Honor pointed out, because when he does have this time for fabrication, when he has time to reflect, he expresses a different desire. He doesn't want to say that Monet and her father tried to kill him. He wants to protect defendant because he wants his son to have her mother. So I believe that the statement was properly admitted, and to the extent there was any problem with the excited utterance, given the overwhelming weight of the other evidence, particularly that video, which depicts the entire crime, there was no doubt that the outcome would have been different. So if there are no other questions, I ask that you affirm and I rest on my brief. Thank you very much.
Thank you.
Part of the issue with the court admitting this statement under the excited utterance exception is that the court really completely discredited the testimony of the witness, Ms. Wilson, who actually saw Mr. Hayes closer in proximity to the event and would have been better positioned to testify as to his demeanor when he was closer in proximity to the shooting, and therefore been the best situated person to testify as to whether he was still under the stress or excitement that that event caused. The only testimony elicited from that witness was that he appeared aggravated. And so to the extent that the concern here, and I think it is, and it is the standard.
That was a girlfriend, correct?
Yes.
That was the victim's girlfriend, and she really didn't want to come in and testify, so she was not that cooperative at all.
She answered the questions put to her and testified under oath, and you know, I think to the extent that the court discredited her testimony and it was closer in proximity, that was significant error. I also think that there's something to be said for the fact that Ms. Wilson is involved in these underlying events. She's present at the time that the initial argument breaks out. I think it would have been right for the court to at least consider whether there would have been a conversation that had taken place between Ms. Wilson and Mr. Hayes as to the defendant appellant's
But there was nothing in the
involvement
record,
here.
as I understood, that prevented the defense counsel to cross-examine Ms. Wilson. Am I correct, or am I missing something? I mean, all the points you're raising now were subject to cross-examination, no? I mean,
If I may respond.
Yes.
Yes, and there would have been no incentive for defense counsel to cross-examine her on that point because she testified exactly from a strategic perspective how defense counsel would have wanted her to. She didn't put anything on the record that would have evinced any concern to defense at the time that this would have qualified under the excited utterance exception because Mr. Hayes didn't appear to be under the stress or excitement that the event had caused based on what she had testified to. Thank you.
Thank you. Thank you both. Phillips versus Murtha.
Good afternoon, Your Honors. My name is Ambrose Richards, and I represent Appellate Jessica Phillips. Let me start with the unremarkable proposition that lawyers can commit torts, whether it's negligence, trespass, assault, discrimination, conversion. And duties are owed to anyone to whom injury is foreseeable. Privity is not necessary for a claim of negligence. I mean, that was established expressly by the Court of Appeals in Landon versus Kroll.
Well, where we're talking about estate planning and malpractice, does there not have to be privity?
We're not talking about, there was no claim of malpractice. We are talking about estate planning. The issue, if I may address it, Your Honor, which I think is important, is whether Jessica Phillips can claim to be injured by the actions or failure to act by Mr. Murtha.
Right, some type of negligence on the part of Mr. Murtha.
That's correct.
In drafting the will and the estate planning.
That's correct, Your Honor.
But when we're talking about that negligence, is privity not necessary?
I believe it is not, Your Honor, not in a case of negligence. It's only if injury to her is foreseeable, and my point is this.
where's the duty?
Where's the duty? I'm sorry.
Well, I think the duty is to anyone who would suffer injury or harm as a result of your
An
negligence.
attorney has a duty to anybody who might be suffered by the attorney following his or her client's wishes?
And that's pretty expansive if that's what you're arguing, because every lawyer in this courtroom is going to start shuddering.
I
Any
think
case law to support that?
well, actually, yeah, I do, if I will get to that. Yeah, yes, I do think.
Oh, yeah, could you get to it now? I'm sorry, if you could get to it now in response to my colleague's question.
Okay, so, this case has evolved over time, and our proceedings ongoing in the surrogate's court. They were delayed by over a year because the original will was missing, and the parties briefed whether or not the court could admit a copy of the will. So that's sort of running behind what's happening here. What came out in the 1404 depositions, was Mr. Murtha submitted or disclosed supposedly his entire file, which did not include any retainer agreement, any time records, any billing records, any statements of that he had been paid by the decedent.
Failure to keep good records isn't per se malpractice, and it still doesn't establish whether or not he had a duty to Ms. Phillips.
Well, I think the inference from the records, the inference that I drew and what was striking to me is that Mr. Murtha did not disclose to the decedent his conflict of interest. Mr.
I don't
Murtha.
know. First, you have to establish that there was a conflict. And he was very specific in his deposition that whenever he and Miss, what's her name? And the decedent, when Miss Petrucci
Ms. Knapp.
actually discussed substance, that he always required that her caretaker leave the room. So I don't understand where you, from the basis of your inference that there was a
I
conflict
think
of interest.
And I'm still focused on the privity issue. And I'm thinking of a state of Schneider versus Finman, wherein I thought the court had stated, the Court of Appeals had stated that privity is necessary, strict privity is necessary.
Well, in that case, they said that the representative of the estate did have standing to bring suit against the attorneys, not the various beneficiaries didn't have standing. But in this case, we have kind of a catch-21, because at
Right,
least...
because she's not the representative of the estate.
No, the co-conspirator is the representative of the estate. The other person who is accused of undue influence is the representative of the estate, and she's not going to bring proceedings against herself.
That's if you can establish that there's some co-conspiracy going on because of some type of undue influence that she exerted over the decedent.
Well, let me please point out that this is a motion to dismiss that may or may not be proved, but we are alleging that, and I think we need to assume
But you
that
still
that
have
would be
to allege a
proven.
basis for duty, and I don't, or
Okay,
privity.
let me
I
go
don't
back.
understand- Excuse me, I don't see any allegations in your complaint.
Right, so I have a
which
copy.
Can be inferred.
So I have a copy of your complaint, and so could you point to me where in your complaint there are sufficient allegations as to privity and the duty?
Well, we did not, as I said, this was a claim not for malpractice, but it was a claim for,
It's a claim for negligence, you
it
still.
was a claim for negligence, yes,
Okay,
it was a
so
claim for
where in your
negligence.
complaint are there specific allegations as to a duty owed? Because I don't see it.
Well, okay. The question, I mean, I said that Mr. Murtha had a duty to protect Ms. Knapp from undue influence. I believe on account of the prominence of Ms. Phillips in Mr. Murtha's notes, in his assurance and promise to her that she had a reasonable expectation, you know, that she would benefit from Ms. Knapp's estate.
But she was given a bequest of $50,000. Why is that? I mean, it's not that she received nothing from the estate.
Well, if she received like 1% of what she otherwise would have received, that's
I
not
don't know
nothing.
where
I
the
mean, this is,
otherwise comes from.
this is a $7 million estate, Your Honor.
But I don't understand where the otherwise comes from. The only statement you have is a statement allegedly by Ms. I keep forgetting her name, Castrucci Knapp to Ms. Phillips saying, you'll get a lot of money when I die. That could have been referring to the $50,000, couldn't
Well,
it?
it could be referring to the $6 million next to her name in Mr. Murtha's notes. I mean, as I said, we're not determining facts here, we're dealing with allegations. Is there a claim?
So I
where
still
are
don't
your
see any allegations.
About duty.
Okay,
I'm
well,
still looking. Why don't you look on rebuttal? You have a seat, take a look at the complaint, show me what I'm missing, and then on rebuttal, you can point me to the paragraph.
Sure.
Thank you. If you want to remain seated, oh, I guess we don't have a mic for you.
Thank you, Your Honor, I appreciate that. Matthew Flanagan for the respondents, Michael Murtha and Murtha Law, PLLC. As the court has noted, strict privity remains a requirement.
I got a simple question.
Sure.
I'm reading through this entire record here. This all should be in surrogate's court, right? I mean, if there's a challenge to the will where this plaintiff here is saying, this is not the will that I thought it would be, this all is a surrogate's issue, right? Why are
Exactly,
we?
Your
In,
Honor. Sure.
and in fact, if it's challenging the attorney's role, the surrogate, I think, can handle that too, because I've seen that situation come up, right?
Well, as a former acting surrogate, I would
you
say
go.
that we could handle it.
There you go. Right?
Surrogates court could
So
handle it.
why are we having two battles on two fronts?
Yeah, good question, Your Honor. And it does belong in surrogates court. It is being litigated in surrogates court.
So that was my question also. Are there portions of this litigation that are also being addressed in surrogates court in terms of Mr. Murtha's involvement in, in terms of alleged undue influence, et cetera?
Correct, Your Honor. The claim of undue influence is being made in surrogates courts, being litigated there. Mr. Murtha testified at a 1404 examination in connection with that surrogates court proceeding. So it is being litigated there, and that is where it belongs.
And it's an
in our
open
view.
issue still in the surrogates court.
I'm sorry, Your Honor?
And it's still an open issue in surrogates court, is that
I
correct?
believe it's still being litigated. I'm not certain, but I believe it is.
So why are we litigating in both Supreme Court as well as surrogates court?
Good question, Your Honor.
I know.
And, the lack of privity is one of the hurdles that the plaintiff has. The other one, as we pointed out in our brief, is the statute of limitations. This was
Listen, but you know what, buying his argument that this is not legal malpractice, we don't have to look to strict privity, I still don't see the duty element. I mean, what he's arguing is pretty earth-shaking. I mean, for any attorney, like, what? I have duty to somebody I don't even know?
well put, Your Honor. And it should make attorneys
That
shudder.
takes Espinal to another level.
Right, true, Your Honor. And it does make attorneys shudder, as you stated earlier.
I mean, you can feel the earth shake already. Even in this room, the attorney's like, what?
So it is, and the Court of Appeals has addressed it. They addressed it in 2010 and reaffirmed the privity requirement in New York, thankfully for all of us on this side, and that's a good thing. And just one last point, the plaintiff can't avoid the privity requirement by calling it a negligence claim, and the Court of Appeals has addressed that as well. They said, a negligence in the performance of professional duties is a malpractice claim. So you can't call it a negligence claim in order to get around the accrual rules and the statute of limitations for a malpractice claim. And lastly, the only duty that's alleged in the complaint, and that was asked of the plaintiff, and this is at the record at 24 and 32, it's in paragraph 25 of both the initial complaint and the amended complaint. The duty owed by Mr. Murtha was to Mrs. Knapp.
Right, well, paragraph 25 is, as attorney for Mrs. Knapp, Murtha had a duty to her to protect her from undue influence.
Exactly, Your Honor.
That's paragraph 25. So I don't see anything else in the complaint as to any duty owed to the plaintiff here,
Correct, Your Honor.
to Phillips.
That's exactly right, Your Honor.
Unless the argument is that the duty owed to the decedent therefore flows to the plaintiff.
Well, then it would flow to the plaintiff, it would flow to all the other beneficiaries,
Yes.
and there were a number, and then that would even multiply the shuddering felt by the attorneys. So for the reasons we've stated in our brief and here today, we ask that the lower court's judgment be affirmed. Thank you.
Thank you.
So were you able to locate any reference to duty?
No, it's this,
Excuse me, to duty. Excuse me? May I finish the question? Were you able to find in the complaint any reference to a duty by Mr. Murtha to your client?
There's no specific reference to a duty to my client.
Thank
It was, I think, the question that we have here under Leah Martinez is there a cause of action, not whether or not it's been explicitly stated. And as I said, I think she had a reasonable expectancy under the circumstances here, and it isn't even clear if there is any damage because there are proceedings in the surrogate's court. It's a matter sort of a procedural accident that we happen to be here before the other one.
Well, it's a procedural choice on your part, not an accident.
It was a procedural choice to bring an action against the attorney before the statute of limitations has run, which was done.
So that's the question. How do you have proceedings both in Supreme Court as well as surrogates court
Because there
at the
is,
same time? It would seem to me what I thought normally happened from my experience was that one would be transferred to the other. Normally Supreme Court would transfer to surrogates court.
I think it's because a motion to dismiss was promptly made based on the early filings here.
So this is a 3211 case, right? And so the question is, I guess, if you proceed, then there would be additional discovery. So what additional discovery could there be or would there be that would show that there would be some type of duty owed to your client?
Yeah, there would be discovery of the decedent's neighbors, doctors, financial advisors, and so forth, prior
So
attorneys,
again-
prior attorneys.
How would that again show that there was any duty owed to your client by Mr. Murtha?
And I think further discussions with Mr. Murtha. If it turned out that Mr. Murtha had active involvement with the caregiver who is the primary beneficiary of his efforts, I think it would be probative,
There are
of the
no
fact that they had
allegations of
conspired.
that,
What?
correct? There are no allegations of that, right?
Yeah, there were in the second, the conspiracy to defraud, yes. I mean, that was the allegation. That was the second cause of action.
But that again will be dealt with, and I'm assuming it's being dealt with in surrogate's court, right? Because that goes to the undue influence.
Yes, Your Honor.
Thank you. Thank you both. Concordance Healthcare versus Corey Capital.
May it please the court. I'm Brett Cannon from Lieberman Canine, and I represent the Appellant PAF Statutory Trust. This appeal comes from a motion to dismiss, which was denied related to the two causes of action brought against my client.
Okay, so I got a question. Let's just jump right into it. Why was Supreme Court wrong? Because you're relying on emails to buttress your case, and you're relying on an affidavit that your client produced saying, this is how we thought the transaction went down. My understanding is, you can use an affidavit the plaintiff can use an affidavit to amplify the pleadings on a motion to dismiss, but you're using the affidavit to actually prevail on your motion to dismiss. That's the first point. I mean, there's a lot going on here, right? It was all based on emails. Why couldn't your client just get a simple document signed by everybody saying, you know what, you're no longer the escrow agent, thanks so much, goodbye? Well, that's all we needed. So why wasn't it there?
Well, I think it is there, Your Honor. I think.
Oh, there is a signed document from all three parties.
Show us where it is.
Yeah.
I couldn't find it.
The letter.
Sort of in sync here, so you got to be careful.
Sure. Sure, the letter agreement. The letter agreement is, what was going on in this situation was they were not able to close on this agreement because they needed.
We know what was
We
going
know
on.
they needed a letter of credit, and the bank at the time, CNB, City National Bank, couldn't provide the letter of credit. So they said, you know what, Bank of America can do the letter of credit, but the escrow agent doesn't have a relationship with Bank of America, and blah, 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 blah. So all that's fine, but where is it? Just point to the record, just show us. Maybe we
At
overlooked
89, Your Honor, the letter agreement, which is signed by the two parties to the escrow agreement.
Right.
My client was the escrow agent.
Right.
And there is a joint instruction from two parties to an escrow agreement. Pursuant to the terms of the escrow agreement, my client could rely on a joint instruction.
That would to be transferring the money for CNB to B of A.
Yes.
That's right. But does that letter say, and by the way, we also agreed that there's no longer an escrow agreement in play? I was looking for that. I didn't see that.
Well, Your Honor, I believe it doesn't matter. That explicit.
Oh, well, wait a
that
second. Hold on a second. Isn't there a part of the escrow agreement that says the money's going to be held at City National Bank account and any additional bank? Doesn't it say that in section?
It does, Your Honor, but that was changed by the letter agreement. The letter agreement signed by both escrow parties said that it was going to be transferred to Bank of America.
I don't think we have a
And the
problem with
parties
that.
understood that the Bank of America account was going to be administered by Corey Capital. And also, Your Honor.
Why? I don't, how do you make that leap? I don't see how you
At
make
90,
that leap.
Your Honor, at the record at 90. once the principal of Park Avenue, PAF statutory trust received the joint instruction for the money to be transferred, then he wrote, the very same day, he wrote to the CFO of plaintiff, and he said, I just wanted to confirm I received this signed written agreement. I would like to confirm that.
Yeah, but does the letter go on to say, we're confirming that the money went from CNB to B of A? Does the letter, unless I please correct me if I'm wrong, does the letter say, and by the way, we're no longer your escrow agent?
Yes, Your Honor.
Does say
It
that.
says, just to confirm that you approve the funds transfer out of the PAF statutory trust escrow program and into a new account administered by Corey Capital at Bank of New York. And the CFO of the plaintiff responded, approved, confirmed. So that document, which, and I would also like to point out that emails as well as contracts and the letter are
Counsel,
clear.
I see that document, I've got it in front of me, but I don't see where it says that anybody from PAF said, and now we are no longer the escrow agent. And that seems to me a really critical piece that is missing from this string of emails and letters and texts and so on. They never
Your
say
Honor.
that we agree that by virtue of this transfer, we're out of the picture now. Where does it say that?
Your Honor, my client did not
Counsel,
draft.
where, does it say that anywhere?
I believe that it says it in that
Where?
email. I believe in that email when it says it is going to be administered by Corey Capital at Bank of America. If it was being taken out of the PAF statutory escrow program, then clearly they could not be the escrow agent in control of the funds.
It wouldn't make, it's not a stretch to say that Corey's administering the Bank of America accounts, since Corey has a banking relationship with Bank of America. But what I'm trying to struggle with is that you can have a relationship with a financial institution, but that does not necessarily translate. It's your reading of that letter saying that it translates into releasing the escrow agent of its obligations. It would have been more clear, to have it in writing or an email. This is to confirm that we're no longer your escrow agent and the escrow agreement is no longer in play. That would have been a simple thing to write. But you have all these buzzwords going back and forth, and everybody sort of left wondering, or not left wondering. Everyone has a different interpretation as to what's going on here. I mean, clearly, as what the respondent, in terms of their response to the motion to dismiss, say, no, wait a second, that's not how we understood it. So once you get into that kind of dispute, you're past the documentary evidence portion of this.
Well, but Your Honor, what is not in dispute is that the parties intended that transfer to be done. And my client,
But counsel, the
pursuant
problem
to
is that it was done pursuant to the agreement, as you pointed out on page 89 of the record, which says specifically the changing banking platforms, quote, will have no impact on the terms of holding and release of funds as per the original agreement, close quote. So given that language on page 89, it seems to me that that Concordance was entitled to believe that your client would continue to be the escrow agent because this transfer was without prejudice to your continuation as the escrow agent.
Well, I disagree respectfully, Your Honor.
So how do you read, excuse me, could you explain to me how you read that clause and what it means in the context of the agreement that you claim now exists?
I will, Your Honor. This letter agreement was between Concordance and Corey Capital. It was drafted by Corey Capital, and it was sent to Concordance, and presumably they both read it and signed it.
Essentially, the fox guarding the hen house, right?
My client was not a party to that agreement. When my client received the joint instruction, under the escrow agreement, he is allowed to receive a joint instruction at his discretion and in his judgment and rely on that joint instruction to transfer the money. So to confirm what he was reading and his knowledge of what he was reading, he sent the email. And I will address that sentence. The parties had discussed before that Corey had the relationship with Bank of America. It had to be sent to Corey Capital's Bank of America account, and it even references in the letter that it was being sent there for a letter of credit. A letter of credit is when a bank holds money in escrow so that it guarantees payment to a
Yeah,
manufacturer.
we know what a letter of credit is,
Right.
but
So-
think about this thought, because I think your time is up. Think about this thought. You're trying to equate and elevate the transfer of funds from two different platforms to a release of the escrow agreement. That's what you're trying to argue here. So think about that response when you come back on rebuttal, right?
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. My name is Chris LaRocco of Bryan Cave, Leighton Paisner, here for the respondent. Let me just say that I believe that the panel here has identified.
Is it right? They're trying to equate the transferring of the funds from two different platforms to a release of the escrow agreement.
I believe that is correct. And
Right?
again,
Simple in terms. Once you transfer the money from CNB to Bank of America, that automatically releases us from the escrow obligation.
That's the gist of what they're saying, and I would agree with the questioning earlier as well, in the sense that there is clearly a dispute about what the intent of these communications was. And I'm not doubting Mr. Cana's interpretation of what his client believed, but as set forth in the complaint, our client had a completely different understanding of this situation. And as the escrow agent with fiduciary duties, you would expect that that would be the party who would have the responsibility to very clearly say in a transfer notice, in a, what he calls a letter agreement, which again was never signed by one of the parties to the agreement, PAF statutory trust. But in any event, that would say very clearly, this is the end of our relationship, or please be aware that this means, we'll no longer be able to protect your interests, or that we're giving total control to Corey Capital, which is not in any of those
But it
statements.
seems to me we're again on the issue of duty, and I'm not sure why PAF had a duty to explain to your client, presumably a sophisticated business, what was happening, and why didn't your client have an obligation to do some due diligence and say, gee, if it's going to a bank where Corey has a relationship, is this a good deal? What does this really do? How does that affect the safety of my escrow account?
Right.
Why isn't that your client's duty instead of PAF's?
Well, I believe, fraud is one of the claims in this case, and I'll say that if you read that notice, it does, again, I think this was quoted, it says specifically that the obligations with respect to holding and release are not being changed. So our client relied on that representation, and again, it's characterized as an agreement by the appellant, but not by us. This was a notice received by Corey Capital, which said, hey, we got to change bank accounts here. It's not going to change anything else about the agreement, and we relied upon that. And to the extent that PAF, which now is sort of suggesting that even at that time it knew that it would no longer be involved, that's not something that our client was privy to. So to the extent that there was a due diligence requirement, I'm not sure that that's required under the law, especially when you have a fiduciary and you have a representation from the other side in which we had no reason not to believe that, given the fact that, as again pointed out by the panel, the agreement contemplates a change in bank account. So again, we understood that there was some complication with respect to a letter of credit, needed to change a bank account, so Bank of America would issue a letter of credit, but that was the end of it. And to equate that as, okay, we understand there's going to be a transfer of bank accounts to PAF is no longer going to be protecting your interests. In fact, PAF is going to give total control of these funds to Corey Capital, is a completely different scenario than what was represented to us, which was, again, that we're going to change bank accounts, but nothing else about this agreement, or even, specifically, the terms with respect to holding and release of these escrow funds are going to be the same as they were in the parties' prior agreement, which of course say that, they will only be released under specific conditions that weren't met here.
Counsel, can you address your client's request of the return of the funds, not from PAF, but from Corey Capital initially?
Right. Absolutely. Again, the issue there was confusion with respect to where the funds ended up. And so the initial, having been the party opposite, right, it is true that we contracted with Corey Capital for the purchase of these medical supplies. And so the issue was brought directly to them because they were the ones who kept promising performance, which never came. And in fact, there was a second agreement, which is part of the complaint, but not at issue here on this appeal, that was a guarantee agreement. So, which did, I should say, establish additional damages if certain dates weren't met, which they weren't met by the time that those demands were made. So we were demanding a return of the price, which we assumed at the time that they would then work with PAF to make sure that those funds were released, but that the communication was directly to Corey Capital until we realized that Corey Capital was not going to cooperate. And then we went to the escrow agent to say, okay, this is not working. You have to understand we've done everything we need to do to recover these funds from, and therefore they should be released. And at that time, learned that PAF was not able to comply with that directive. Again, I have no further points. I would just like to raise, I guess, one issue on the fiduciary duties. I think it should be obvious, but I wanted to make it clear to the extent that it's been called into question as to whether or not the fiduciary duty claim is separate than the breach of contract claim. Again, the contract calls for the release of these funds upon certain conditions being met. That was not done. That's a breach of contract. Again, I think as we discussed, to make it clear, the fiduciary duties at issue are these duties of disclosure and of candor in terms of what what the implications were of this, and to the extent that you're going to make a communication like they did, it should say more than, something about an escrow program and an administration that, again, we understood it differently. And to the extent that we're interpreting these agreements, you're already outside of 3211, and I think that should be made clear. And I think I can leave it at that and save the court a couple of minutes of time unless you have further questions.
Thank you. I know, exactly. Hey, I'll take it.
Thank you, Your Honors. I would just like to point out one thing about the letter agreement also, and that phrase. If this was merely a transfer of funds from one PAF account to another controlled PAF account, there'd be no need for that line in this agreement. PAF was the escrow agent. Why would you put that line in that agreement? But for the fact that these parties, who were the parties to this letter agreement, Corey Capital and Concordance, were agreeing that I know this money is going into a different bank, so it could be part of a letter of credit, and pursuant to that letter of credit, the release of those funds will remain the same.
I'm sorry, I still don't understand what, under that theory, how you read the sentence beginning, the change in banking platforms will have no impact on the terms of holding and release of funds.
Because they were...
Aren't you sort of reading that out of the letter on page 89 of the record?
Right. This letter was
You're just saying that was written in invisible ink?
No, what I'm saying is that this letter was an agreement between Corey Capital and Concordance. Park Avenue Finance wasn't a party to this agreement. There was no need, if what was contemplated by this transfer was merely a transfer between an account that was in the control of Park Avenue, PAF.
Didn't your client have this letter in front of it when it made that transfer?
Yes, Your Honor, and that's why...
So why wouldn't it have understood that it was still under the term, it was still acting as escrow agent?
Because the interpretation of that line is this is not an agreement with PAF. This is an agreement...
Exactly. So that's what I'm not understanding. You're stating that you were not a party to this agreement between Corey and Concordance to transfer the funds to Bank of America. Is that correct?
Right, because this was a joint instruction.
So if you're not, right, so if you're not a party to that agreement, why then is your agreement not still in effect between Corey and Concordance?
Because this is a joint instruction, and pursuant to the terms of the escrow agreement...
But you're not a party, so therefore therefore it doesn't affect the original agreement between the three of you.
No, pursuant to the terms of the escrow agreement, which was the three parties, the escrow agent is allowed to rely on a joint instruction. That's what this is. My client does not have to...
The joint instruction says it will have no impact on your client's obligation.
Exactly. So...
Well, no, that's not what it says, Your Honor. It says it will not have effect on the terms of holding and release of the funds. So that this was...
yeah, that, exactly.
No, Your Honor, but this is meaning that the letter of credit which was going to be issued would be released by Corey, which was confirmed in the email.
And how do we know that? I'm not, I mean, it seems like you're...
It was confirmed in the email. The email that was sent to the CFO who said it will be now administered by Corey Capital. That's what the email says. And there's no other way to interpret that email. It is no longer...
So again, I do not understand why at that point in time, as a business, who owed a fiduciary duty at some point in time, why you would not follow up and say, just to be clear, our obligations are now finished. We no longer have any obligations under this agreement? I mean,
it-
you're holding, you're escrow agent. I
Well-
would think that that's what you would say.
I don't think my client has an obligation to
Right, and see where that lack of obligation got him? Got your client?
I'm sorry, what was
Here.
that?
Thank you. Have a good day.
Thank you, Your Honors.
Okay, People v. Francisco Vasquez. Cover your mouth when you cough. I can't sit with him anymore. This is why I can't sit with him anymore. I can't sit with him.
She's disparaging me. She's disparaging.
May it
Whenever
please,
you're ready.
okay, may it please the court, Alma Gonzalez for Mr. Vega Vasquez. The court should reduce Mr. Vega Vasquez's sentence. His conduct in this case was...
So he finished his sentence.
No, he's still on post-release supervision.
Right, but he finished the incarceratory portion of the sentence. He's now on post-release supervision, and my understanding is that post-release supervision is going to terminate sometime soon, right?
Correct, Your Honor, but a
When does it
sentence-
terminate?
I believe in May.
May. This
yes.
is March?
Yes.
So it terminates in a couple of months.
It does, but the reason why we're still asking for a sentence reduction is because of his physical health. A sentence reduction in this case would have really a
So
significant...
the 2 months is going to make a difference to his physical health, how?
It does, because he's currently, because of PRS, he's currently living in Buffalo, which means he's isolated completely from
Because his family lives in Puerto Rico?
in Puerto Rico and
And
in
so
various
the supervising probation officer or whatever would not give him permission to go to Puerto Rico?
Well, probation could deny.
Has he requested?
I mean, that would be outside of the record. I believe he has on at least one occasion because his father had passed away, which I believe was granted, but.
Right. See, my experience in these cases is that, you know what, if you request to move to another state, in this case, Puerto Rico, which is a part of the United States, it would be granted, because normally New York is happy to get rid of probationers because it's less work for the probationers here, for probation officers here in New York. So I'm a little surprised that we're talking about 2 months to transfer to Puerto Rico from Buffalo, which again, I can understand why he'd want to leave Buffalo this time of year.
Well, yeah, and he doesn't necessarily have the financial means to do that right away, which is why he has spent his time in Buffalo rather than moving back to Puerto Rico. And the other significant aspect of this as well is that there really is no need to continue supervising him at this point.
So you're just asking for 1 year post-release supervision?
Correct, yes, Your Honor.
I'm confused about your saying that he has no family in New York. What about his co-defendant's son, who your client apparently introduced to the drug trade?
I don't think that there's any evidence in the record that our client introduced his co-defendant to this.
Well, his son was a part of the drug trafficking as well. So the question is not his son, who was a co-defendant in this drug trafficking case, also residing in New York?
It's unclear because he actually got off of PRS some years ago. So on this record, I can't really say where he is. The only person that is in New York State is his mother, but she lives in the Bronx and she's elderly, so she's not really in a position to care for him. She actually is the person who needs to be cared for. And based on the mitigating circumstances in this case, which I think are sufficiently outlined in the briefs, we do believe that a minimum
Counsel,
sentence
his sentence got reduced because of good behavior or whatever, right? He got released early, correct?
Correct, yes.
So how does we have now the less is more statute in play here. How does that, I didn't see anything here, but that may affect whether or not he can get off PRS now.
Well, that's actually why he would be off in May, presumably if he continues to not violate.
You already factored in the less is more
Correct,
conditions,
yes.
so that he would be getting out in May then, right? Okay.
Right, because currently it's set for July, I believe.
I think, is he 53?
He's 57, going on
57.
58.
What are his medical issues?
So he's
His health
actually,
issues?
he's at 100% military disability due to a service-related disability, which I believe is his psychoaffective disorder, which was caused or triggered during his service. And he also has physical injuries because of the fall that was the reason why he ended up with an opioid addiction. And this is outside of the record.
Oh, so these are maladies that he had when he was a part of this widespread drug trafficking.
Well, the
Right.
schizoaffective disorder, yes, and then the back injury that he suffered was right before.
Right, that was in 2012? Well, no, I'm sorry, yeah, the back injury was, okay.
Correct.
These were things that were already considered by the sentencing court when they decided to lower and offer him a plea to a B felony as opposed to an A1.
It was not actually, Your Honor, because at the time, the plea court was the court that reached the sentence, but the sentencing court was a different judge, first of all, and the plea court also didn't have the benefit of the reports from the City Department of Corrections, which actually recommended a program, as well as from the Osborne Association. So they didn't really have the whole.
But they knew about the issues from his service, his veteran service.
And his psychiatric issues.
And the psychiatric issues.
I don't believe that the plea court did, and the sentencing court did not mention that.
Well, where did I see that he had a BS, that he was a Army vet, and that he had run his own business at some point in time? Not the drug business, but a separate business at some point in time.
That's in the Osborne Association report, which wasn't available.
So he was facing 25 to life on the A1, and he was sentenced to 7. Is that correct?
Correct, and as was his son, actually, who received a sentence 2 times lower than him, with really no other distinguishing factor.
But he wouldn't obviously be upset that his son, his own flesh and blood, received a lesser sentence than he did, right?
Of course not, but under the principles of proportionality, Mr. Vega Vasquez should also receive a similar sentence.
It is an unbecoming argument.
Sorry?
It is not a persuasive or becoming argument for him to make.
Which argument, Your Honor?
That it's a shame his son received a shorter sentence than he did.
Oh, no, that's not what we're arguing. What we're arguing is that he should have received my client should have received a similar sentence under the circumstances.
Thank you.
Thank you, Your Honors.
Yeah, ma'am. We're talking about a couple of months. Why not just reduce to post-release supervision?
There's no factor that would warrant a reduction in this case. He received an incredibly favorable plea bargain. In this case, he was able to get a negotiated sentence of 7 years and a B felony conviction when he was facing 3 A1 charges, including operating as a major trafficker, which could have, as the court just pointed out, have resulted in a sentence that would effectively have been a life sentence for someone who was 53. And the factors that he's brought up do not warrant a reduction. The drug abuse history was something that he actually denied having at the pre-sentence interview. The mental health history has no causal connection to the charges here. And finally, he's chosen 1 co-defendant out of 13, out of 5, even though he had 5 others who were actually charged as major traffickers also, to compare himself to. And that particular co-defendant, his son, is far younger and charged with fewer offenses. And furthermore, he never made an adequate record to reveal what the son's circumstances were, so it's impossible to actually compare and determine whether the sentences should be comparable or not here. Apart from all these things, he waived his right to appeal validly, and this court should not even reach the severity of the sentence. The court here carefully, just as in Bryant, which the defendant has never distinguished, separated the discussion of the trial rights from the discussion of the appellate rights, made sure that he had discussed with his counsel the nature of the right to appeal and the consequences of waiver, and also had him sign in open court a detailed written waiver that made clear that the right to appeal is separate and distinct from the rights automatically forfeited. Nor was there any problem in conveying the right to counsel here. The court conveyed it as part of the right to appeal, and the limitations on the right to appeal that the waiver would effect were as detailed by the written waiver and in the court's colloquy, were with respect to the issues that could be raised, not with respect to the right to counsel. Therefore, because he validly waived his right to appeal, which should be enforced, and because there's absolutely no reason to reduce his sentence here, this court should affirm the conviction in all respects. I would just like to quickly address one thing that the court brought up, and that is when his sentence will actually expire. Under the Less is More Act, we believe it would be September 12th, because he still has a little bit of the underlying prison term to add to his PRS term that he would need to finish, assuming no violations. So the projected date of completion would actually be September 12th, but that is immaterial. That's 5 months instead of 2 months. Therefore, because of the waiver of appeal and because there's no reason to reduce, we ask that the court affirm the conviction in all respects.
Thank you.
Thank you.
First, on the appeal waiver is invalid for the reasons that we stated in the briefs, primarily because it mischaracterized the waiver as encompassing the waiver of his appellate rights. But as to my adversary's last point about Mr. Vega-Vasquez getting off in September, 2 months is significant to him already for the reasons that we outlined. Waiting until September is that much more meaningful to him than if that's the case, because it means the prolonged isolation, physical isolation from his family.
He has family in the Bronx.
He only has his mother there, but she's elderly, so she can't actually care for him.
What care does he need? I'm not really understanding. He can't receive this care in the Bronx, but he can only receive it in Puerto Rico, and I'm not really sure what care it is that he requires.
Well, Your Honor, I mean, this is outside of the record, but he has suffered additional physical ailments since then, primarily being diagnosed with cancer, and so it's very difficult for him to have to travel to and from the hospital and care and do daily functions just on his own. And his mother also is an additional person who needs care, so he's not also in a position to care for him as well. So, I mean, for those reasons, it really would be significant for him, and not also to mention the fact that, there really is no need to expend resources supervising him when those could be used to supervise people who are at higher risk of recidivism than he is. So for those reasons, we would ask for a reduction in his sentence.
Thank you. Thank you,
Your Honors.
Amaziano versus Subtronian. So bad. I don't know, something. I don't play music. No.
May it please the court, my name is John Ledane. I'm from Dorff and Nelson. I've put a brief before you which indicates that this court really has 5 reasons to dismiss the complaint in this case, and I'd be happy to address them in order unless somebody has a question about 1 or 2 of them that's burning in their minds. We've got a situation where a single issue was determined against the defendant doctor at trial in a case where there was a 48-hour course of treatment that led to diagnosis of appendicitis. But Dr. Subramanian was a consulting radiologist who read.
Well, this is an interesting scenario, is that the actual referring physician testifies and says, I only sent the patient to the defendant doctor here, your client, for a specific sonogram, for a specific ultrasound.
Correct, because
right?
she's a gynecologist, so she sent the patient to determine whether this is a gynecological condition.
He gets a referral, and that's all he's looking for. That's all he's doing, right?
Correct. He exceeded the standard of care by going beyond the GYN ultrasound.
Right, because he says that since he couldn't find anything, he figured, let me do another ultrasound and see whether or not I can find a reason for her pain.
And there's also evidence in the record that the ultrasound is not a procedure to use to even look for appendicitis. And none of the experts really quibbled with that, right? I mean, that's what he was told to do an ultrasound and a sonogram, and that's all I want you to do, right?
Let's put it this way. He did a GYN ultrasound to look for an ectopic pregnancy because that's the usual cause of pain in early pregnancy. When he found that the situs of the pregnancy was within the uterus, it wasn't an ectopic pregnancy. And then he did an evaluation of all the other pelvic organs, the GYN organs, and determined that there was no abnormality there. Then he took the scan and he went to the periumbilical area, which is right around the umbilicus, and in the lower right quadrant, which is coincidentally where the appendix is. But the ultrasound is not the equipment that's supposed to find those disorders.
Yeah,
So
there's nothing in the record, unless, please correct me if I'm wrong, there's nothing in the record that he should have done more, that he should, in addition to the sonogram, he should have done an MRI.
he exceeded the standard of care in multiple fashions.
But that
here.
wasn't the argument put forth by plaintiffs, was that because in his record, in the report, he stated no abnormality, that notation misled the obstetrician, Dr. Skaletsky.
Well,
right?
Dr. Skaletsky.
Well, misled her, let me just finish, misled her to believe that he was able to visualize the appendix, and/or in visualizing the appendix, it was, he could tell whether it was normal or abnormal.
No, that's, well, first
That
off.
was the argument, was it
Well,
not?
well-
That because of that notation, it misled her in making a further diagnosis?
Well, the argument, the argument was not that she was misled, because she said, she specifically said that she wasn't misled. All she sent him there was, she sent the patient there to rule out the GYN question, and once the GYN question was ruled out, she told the doctor on the telephone, okay, give her a copy of the report.
Right.
Sending her. They never discussed appendicitis. You know, appendicitis was diagnosed in a hospital 2 days later. At this time that they were dealing with this patient, they had a patient who was in early pregnancy with abdominal pain. She could have abdominal pain for 40 reasons.
But what I just stated, that was the question that was put to the jury. The two questions that were put to the jury was whether or not he departed from good and accepted medical practice by reporting that he found no abnormality, and whether that departure caused injury to the plaintiff.
Yes, that's true. That's true, except look at the way the question is worded at page 499. The counsel asked the question, by stating that the imaging showed no abnormality, the question is, do you have an opinion with a reasonable degree of medical certainty as to whether stating the statement that he did a scan and found no abnormality would be a departure from good and accepted practice? Now, first off, we objected to that because it's not in the bill of particulars or the complaint. But furthermore, there hasn't been established anywhere in this record that there is a standard of care or what the standard of care is. So all we're going to get now is a bare opinion. We're not going to get any facts.
I thought is it Dr. Boxer? I thought Dr. Boxer put
This is Dr. Boxer.
Right.
Dr. Boxer never gave any standard of care for what the report is supposed to say. How's it supposed to be worded? And furthermore, you know, we have an answer which is not an answer to that question.
Right.
The question is, do you have an opinion on the standard of care? He says, his answer is, by stating that the imaging shows no abnormality, it's implying that there is no evidence on the imaging of appendicitis. But there's a subtlety here, and he goes on and on and on and on. And at the very end of his question, this is the operative language. He says, it doesn't give us a lot of useful information, and it could be misinterpreted or somewhat misleading to say, oh, there is no abnormality. There must be nothing going on here. That's not what the doctor said. He didn't say there's no abnormality. He said this modality, which is not a modality to find appendicitis, doesn't show any abnormality. So there's no question here with respect to liability. He doesn't say that there's a departure from the standard of care. He's not even asked the question, because counsel knows that she doesn't have a departure on this record. She doesn't even ask him the question, is that departure a proximate cause or
So the report,
producing cause of injury to the patient. She doesn't even ask the question.
So the report, when it says no abnormality, it's reporting exactly what the referring doctor asked him to report on, right? Whether or not it was a gynecological sonogram. And he says, based on what you're referring to me to look for, there is no
There's no abnormality in the GYN or the abdomen. Correct.
Sir, would you
And the next step is go to the emergency room because it's not a GYN case. So that the referring doctor is out of the picture now. So there's only one way for her to go is to the emergency room.
Counsel, was there anything in the record that linked this report, let's call it the smoking gun colloquially, that influenced Dr. Selitsky advice or to the patient here?
There is not. And this report wasn't
stated a little differently. There's nothing in the record that establishes that this report was a departure to the extent of causing Dr. Selitsky to commit malpractice.
Correct.
Because Dr. Selitsky's testimony and everything that was said on the record before this jury was never contradicted.
Correct. And the report wasn't generated until after they spoke. And they didn't speak about appendicitis. So there's no testimony that Dr. Selitsky even knew what this report said when she made her conversation with the patient, whether she should go to the hospital or not. And then the foreseeability question is that as of the time that Dr. Subramanian has his last conversation with Dr. Selitsky says, put her on the phone. He puts the patient on the phone. Put her on the phone. I'm sending her to the emergency room. Would you give her a copy of the report? So he thinks he's doing the report that day, right there, right now, in order to give it to the patient so she has it in hand when she goes to the emergency room. Where's the foreseeability here? Is he supposed to know that she's not going to go there because something in his report says that there's no abnormality and that might be a trigger that there's no appendicitis, and Dr. Selitsky might think the causation chain is just totally absent here.
Thank you, counsel. You need to go superior.
May it please the court, my name is Michael Zuller. I represent the plaintiff respondent here.
Counsel, even if we were to find that Dr. Subramanian's report was a departure, can you explain to me how that report was a proximate cause of your client's injuries? Because I'm having trouble seeing that.
Yes, I can. This report was really of two scans that this doctor did. The first one was looking for the ectopic pregnancy, which the referring physician suspected, and the second scan that he did in the lower right quadrant was because he himself suspected appendicitis.
No, that's not what he said. He said that he did it because he could not find a reason for her pain. He never said that he suspected appendicitis.
He said that at his deposition.
I was looking at his trial testimony, fine.
You said that
I
in his
I was only looking at the trial testimony. I did not see that that was before the jury, wherein he stated that he thought that there might be an appendicitis.
There would have been no other reason for him to do the lower right quadrant, if not force. The woman came in, a pregnant woman comes in complaining of abdominal pain. He rules out ectopic pregnancy, and then he decides to do a further ultrasound.
Because he said he couldn't figure out what the cause of her pain was.
Okay, and he finds rebound tenderness while he's moving the wand around. And instead of mentioning in his report that he found rebound tenderness, a telltale sign of appendicitis.
Well, also they said that rebound tenderness was subjective, that it depends upon the physician who's performing the examination as to whether there's going to be rebound tenderness or not.
Why not mention it to the referring doctor? Why not mention to the referring doctor, oh, by the way, I did not get a look at the appendix?
Because he testified that that wasn't his job. He says that his job was simply to perform the ultrasound, to render a report. He said it was not his job or his position, his job to, tell other physicians what they should do or how they should proceed with the results that he gives.
It's not that we're claiming he should have recommended a further course of treatment. We know that that issue was knocked out of the case. What this doctor should have done is communicate fully what his findings were.
But what I found also interesting, Counselor, is Dr. Seletsky specifically testified that she really didn't, first of all, she couldn't remember whether she read the report. She didn't know if she read the report. She didn't know when she read the report. And she also testified that, to some extent, the report really would not have made any difference to her diagnosis because she was only trying to look to determine whether there was an ectopic pregnancy or not.
This radiologist provided deficient information. It did not communicate as a whole any sense of alarm, any sense of concern, any sense of urgency, and that is why the jury did not believe Dr. Seletsky when she said she sent the patient to the emergency room that day.
But even if it did convey deficient information, which we'll concede that it did, if it's not relied upon by the physician, how then does that create the causation for the injuries?
Because it was deficient and there was no sense of urgency.
But it wasn't relied upon.
But this gynecologist never examined the patient, so she had to rely on something from the radiologist. She never saw the patient. So in spite of and the jury didn't believe her.
My only issue is that you're asking the referring doctor sends it to the defendant doctor with a specific referral saying, I need you to look at X, Y, and Z. What you're saying is that the report is deficient because when it said no abnormalities, that was sort of giving someone a false sense of security. But the doctor, when he gives the report based on what he was told to look for, you're saying that he should have done more. I mean, that's the implication, is that he should have done more, right?
No, Your Honor, I'm saying he did do more. He decided on his own initiative to do a second ultrasound of the lower right quadrant. That is where the appendix is located. The woman came in complaining of pain. He found rebound tenderness. He suspected appendicitis. He goes and looks for appendicitis and then reports no abnormality without mentioning that he found rebound tenderness and that he couldn't see the appendix. So what does that impart to a referring physician? Everything is fine. All is well. No sense of urgency, no reason to send her to the emergency room, and doesn't. And the reason that we know she didn't send her to the emergency room is the next day when she called her referring doctor, the referring doctor didn't ask, hey, how did it go in the emergency room? Because she knew she wasn't going to go.
But again, Seletsky testified that she did not depend upon the report in ruling in or out the possibility of an appendicitis. So I'm not really, I understand what you just stated, that for some reason we cannot believe Seletsky, but I'm not sure why we can't believe her.
Well, it's not that we don't believe her or not believe her. The jury didn't believe her. The jury found that her testimony about sending the patient to the emergency room on the first day that she was referred to the radiologist, the jury didn't believe that. The jury rejected her testimony.
But that has nothing to do whether the credibility of Dr. Seletsky is separate and apart from the burden you had to meet in establishing whether the radiologist's report was a substantial factor in causing the plaintiff's injury. So if regardless of credibility, the jury could believe some of it or all of it or none of it. The bottom line is the jury first found that it was not a departure to have not seen the appendix, correct?
True.
Because we know this isn't the gold standard for that.
Yes.
True?
True.
So now he wrote no abnormality the general way, and they did hear testimony. So the question still left that was asked earlier. What is the link in this causative chain that establishes the failure to explain that I didn't see the abdomen, I'm sorry, the appendix, that I didn't see it, which the jury found was not a departure, but to say it in the report, they found that was the departure. Why that was a substantial factor in causing her injuries, in the delay in getting her to the room. Where's the link when Dr. Seletsky, incontroverted, never saw that report? That just take it with you and go to the emergency room if you accept that. I'm still trying to find that.
Because had he disclosed everything about his findings, he would have made it clear that what he suspected, which was appendicitis, he could not confirm or rule out because he couldn't see the appendix. And he didn't say that.
But counsel,
he didn't say that he couldn't identify the very organ he thought might be diseased.
Counsel, that argument seems to be defeated by your own expert, Dr. Chen, who testified that as soon as there's no gynecological issues detected with the sonogram, then the next thing that he's thinking about is this person has to go to the emergency room because she may have appendicitis. So that's exactly what Dr. Zelensky did, because appendicitis was one of his differential diagnoses. And once he gets the report that says that there are no gynecological issues, that the sonogram did not detect any problems with any of her gynecological organs, then the next thing to do is refer her to the emergency room, according to Dr. Zelensky and according to your expert, because she may have an appendicitis.
But the second scan that he did was not of gynecological organs. It was of the appendix area. Is a different scan.
But at the end of the day, when he does not discover or uncover any problems with her gynecological organs, the next thought in your expert's mind and in Dr. Zelensky's mind, according to him and according to your expert, is go to the emergency room because you may have a problem with your appendix. It may be appendicitis. That's why you have those abdominal pains. So again, the question is, and I think everyone has posted, where's the connection here between the report and the injury?
Because the jury did not believe Dr. Selitsky told my client to go to the emergency room on that first day. So all of that falls apart because of the jury's finding. The jury did not believe Dr. Selitsky told my client to go to the emergency room. Why? Because Dr. Selitsky was not put on any notification or concerned by what Dr. Subramaniam found in his ultrasounds.
But he's not relying on that report. He said it himself.
But we don't know whether the jury believed her or not. The point is, we can't imagine that Dr. Selitsky didn't send the plaintiff to the emergency room because she wanted to do her harm. She only didn't send her because she had no reason to. She was not given any reason to. And that's because the report was deficient. It was misleading.
So why wouldn't that be an out for Dr. Selitsky? She's trying to avoid liability as well, is she not?
Sure.
So why not say, you know what? Because of this report that said no abnormality, I figured the appendix was fine, so I didn't send her to the emergency room.
Because it's a very rare thing for one doctor to point a finger of blame at another doctor.
Really?
Yes.
As opposed to one doctor saying that this doctor did an excellent report, and I don't even know if I read the report, but I mean, he went above and beyond it, but I'm not even sure that I read the report.
Being suspicious of appendicitis and not seeing the appendix and then saying everything is fine, there's no abnormality, that is not good practice, and that's what my expert said. And that's what meant for delay in treatment and a much worse outcome for this patient than she would have had if someone had mentioned in the report, like this radiologist, oh, by the way, I found rebound tenderness. Everybody knows that's part of appendicitis. And by the way, I couldn't see the appendix, even though she might have appendicitis. That would have done enough to tell Selitsky, get this lady to an emergency room for a further workup. But this radiologist didn't do anything. He took the shortest route through the problem, reported no abnormality, and failed to say that he couldn't see the very organ that he suspected might be diseased.
So just as furthering Justice Mendez's commentary, your expert, Dr. Chen, said, this report says no abnormality. When I see that, then my next reaction is go to the emergency room. So let's just say, for argument's sake, that Dr. Selitsky did get that report. It said no abnormalities. Her next thought, based on your expert's testimony, is go to the emergency room. So if anything, the failure of what it's not that the report was bad, because the report did what it was supposed to do, right? Because based on your expert, if I get a report like that, I'm sending the person to the emergency room. So,
well, Chen is the obstetrics expert for us. It was Boxer who was the radiology expert, and Boxer took issue with Subramaniam's report. Boxer, our radiology expert, said that report was deficient and was misleading and mischaracterized a possible
So
problem.
that means you have two experts that are conflicting with each other, because the OBGYN expert says, I get a report that says no abnormalities, I'm sending you to the emergency room. Your other expert, the radiologist, say that's a deficient report. They're not on the same page then. What is it? Is it sufficient or is it not sufficient? I mean, that's where you're going in two different directions, right?
But this appeal is by the radiologist, and it's the plaintiff's expert radiologist whose testimony counts here.
But what you still haven't told us is, even if we agree with your expert that the radiology report was deficient, you still haven't shown us the link between that report and your client's injury.
Because it was deficient, the obstetrician had
The fact that it's deficient doesn't cause it to be the link. You still have to show a causative link between the report and what action was taken in her injury.
If you turn the coin over and look at the other side, had the report been complete, the obstetrician would have been alerted to an urgent problem and would have sent the patient to the emergency room. This report was deficient. This report was misleading. This report gave the obstetrician reason to think all was well when it wasn't. And that's the gravamen of the case. There was delay here because of the way this report was phrased. It's not a question of specific prose or the use of certain words. It's the overall communication as a whole.
But again, the obstetrician testified that she did in fact send your client to the emergency room.
But the jury didn't believe that. They answered that specific question. They don't believe that Selitsky did say to go to the emergency room. That's a specific verdict sheet question, and they rejected Selitsky's testimony on that count.
They found your client to be also a percent responsible for her injury.
Yes.
Was that because she didn't go to the emergency room when told to go?
I think maybe the second day, not the first. Eventually, she went on the second day late in the evening, but she might have gone earlier the second day, but not the first. Or maybe a patient should have taken it upon themselves when two board-certified Manhattan doctors, neither of whom can diagnose appendicitis, when she still has pain, maybe the jury felt she should have taken herself to the emergency room that first day. And that is why she was tagged with some responsibility. But that's what you have here. You have reliance by a referring obstetrician on a radiologist to figure out what the cause of this patient's pain is, and the radiologist reports back no abnormality.
But that physician said that they did not rely on that report to diagnose her appendicitis.
But the jury may have rejected that testimony. It wasn't a specific verdict question, but they obviously did not credit everything Dr. Selitsky said.
I'm just having difficulty here. You have the radiologist, your radiologist expert that says that this is a deficient report. Okay, let's just say, okay, that's right. And then your OBGYN expert says, with this deficient report, I would have sent her to the emergency room. I don't see then how a deficient report is the causative connection to the plaintiff's injury when, even with the report as deficient as your radiologist expert says it is, the OBGYN expert says, if I got this report in its current condition, I would have sent her to the emergency room. So it's less about the report.
I think he's pointing to the negligence of the obstetrician in that sense. Yes, he's an obstetrician looking at what the obstetrician treating my client failed to do.
That's what I'm saying. Then the report has less to do with the link than the obstetrician. I mean, it's what the
But this appeal is
did.
by the radiologist. It's the radiologist's liability here that we're focused on, not the obstetrician.
I'm not disputing that. I'm just saying in terms of the links here that we're saying, you have a report that's bad. Okay, it's a bad report, but your expert, your OBGYN is, piling it on to the treating doctor, saying, yeah, this is what you should have done with this bad report. So it's not so much that the bad report caused the injury, it's what the OBGYN, the treating physician, did with the bad report.
To do, right.
And maybe Dr. Chen is a better doctor than Dr. Selitsky. Maybe he would have not looked at the radiologist's report in the same light as Selitsky did, or didn't.
Okay.
But had the radiologist signaled a possible problem by at least admitting I didn't see the
It doesn't matter
appendix,
because your expert said, with this bad report, I would have sent her to the emergency room. So it doesn't matter whether or not It doesn't, it could be a completely horrible report. Getting that report, your expert said, I would have sent it to the emergency room. So it doesn't, in my mind, I'm thinking through this, and I'm like, your radiologist expert says, this is a horrible report. Okay, but where's the link that that report actually caused the injury? It's you kind of
Because
like,
if it was a good report, it would have produced something different. It was a bad report, and it lulled the obstetrician into thinking nothing is wrong.
But she did not rely on the report. That's what I keep coming back to.
But that's if you believe her testimony,
But
which
you
the
can't
jury
have
did
it
not.
both ways. Either she relied on the report and didn't send your client to the emergency room, or she didn't rely on the report and didn't send your client to the emergency room. To me, it comes out the same way, that the report had nothing to do with any decision that she made, and therefore the report had nothing to do with any injury to the client.
Well, that's if you believe her testimony. And the jury clearly did not
Either
believe
way.
all of it.
Either way, even if you don't believe her testimony that she didn't rely on the report,
it's less.
Still, she didn't rely on the report and she didn't send the client to the emergency room. That means that the report had absolutely no impact on the injury, right?
If you believe she didn't look or rely upon the report.
Either way.
Now, if she looked at the report and relied on it but didn't admit to that, then yes, she was lulled into thinking there's no urgency, there's
If
nothing.
she looked at the report and relied on it and then felt, well, you know what, this is a bad report, and although it says no abnormality, there may be an abnormality, and therefore I should send the client to the hospital. Again, that gets the radiologist off the hook.
No, but she didn't send the client to the hospital. That was the point. Whether it was the operation of her own mind or she was taking into account a report.
We're going around in circles, but thank you.
We went around the world. Just very, very briefly on that last point. Please don't believe that this radiologist said that there was no abnormality. He said that the scans of the periumbilical region and the lower right quadrant showed no abnormality.
Right.
Any layperson knows that what that means is this study didn't answer the question. So now,
well, didn't the doctor also say that unless the appendix was truly inflamed,
you wouldn't expect to see.
You wouldn't expect to see anything like that.
Right, and Dr. Selitsky said, I never even heard of diagnosing appendicitis on an ultrasound. Right. I wouldn't think that that would be a useful tool. And so now it's true that Dr. Chen said that, you know, and Dr. Chen's testimony can be considered on an issue of causation, but he did say that there's a lack of causation here because the deficient report or not, this patient should have gone to the emergency room. Now, you know, maybe Dr. Boxer had a different opinion, but he never said it out loud in court. He was never asked the question as to whether the deficient report.
But
anyway,
yeah, I was trying to struggle with that because at the the expert's saying this is a bad report, but the report really, you got to link it up. The bad report has to be linked up to the injury, right?
Correct.
In this case here, it's a bad. Let's just say, okay, it's a bad report, but Dr. Chen said, this is what I would do with this bad report.
Right, and remember what Boxer said. Boxer said that if you say there is no abnormality, there must be nothing going on here, which we didn't say, that could be potentially misleading. So the question is, if it's potentially misleading, does that mean that the obstetrician was misled, or the radiologist misled her? We don't know. You have to look to the facts of the case. And if you look at the facts of the case, Dr. Selitsky makes it clear that she wasn't misled.
Thank you. Thank you both. South Shore versus First Class. First Class.
She said it.
Ready to do battle. I'm telling you. I always thank the last group of litigants for waiting, but I guess really, in the scheme of things, you really don't have much choice, right?
The problem with coming at the end of the alphabet, I think. Russell Morris for the plaintiffs' appellants, Your Honors. With respect to our motion for partial summary judgment on the Franchise Act claim, 4 parts of that claim are established as a matter of law on this record. First, that the business arrangement sold by the respondents to my clients qualified for the protection of the Franchise Act. Second,
The question really for me is that can parties in their agreement, because they're saying that this is sort of like a licensing agreement or whatever, can they say it's not a franchise agreement, therefore the franchise statute doesn't apply?
Absolutely.
That sort of, to me, sounds like a way of like circumventing a clear law that says you can't do that. There's a law out there that says this is the way it's going to be, and you can't just by words, like Justice Love says, it walks like a duck, sounds like a duck, it's a duck. So everything in there, because they're using your marks, right? So it's not like, I mean, there's a big sign that Tasty Delight. So it's a franchise.
That is exactly correct, Justice.
Because if we left it alone, that would just basically undermine the franchise agreement, because every single whatever is out there is going to say, no franchise agreement, because we say it's no franchise agreement. That way we'll be able to scoot all the regulatory rules with respect to franchise agreements.
That is exactly correct, Justice Lang. You cannot circumvent the Franchise Act by just writing this is not a franchise. Section 687 sub 4 is very clear on this. It says, and I quote, any purported waivers shall be void. You cannot circumvent the Franchise Act simply by writing a proviso. It would undermine the entire purpose of the franchise.
The cases that talk about the waivers are more like waiving specific provisions of the Franchise Act, like certain disclosures, certain, documents that get transferred in the franchise, but nothing really I didn't see that talked about waiving the entire statute, saying that it doesn't apply.
Well, that would be even more egregious under the Franchise
Right,
Act.
yeah.
I mean,
if parts of it can't be done, the whole can't be done, right?
That is exactly right. And we are on, all 4 corners with the elements of a franchise in this case. We have the payment of the $50,000 fee. It's undisputed. We have the fact that they got the rights to the marks for the Delights brand.
Oh, isn't this a no pun intended, signature fact that distinguishes this case from El Toro?
Yeah, exactly right, Your Honor. In El Toro, the court specifically said that it did not have the rights to the marks or the rights to a system. In this case, we touch upon all the elements of the franchise, and so you can't get around the Franchise Act by simply stipulating it.
And so the defendants did not even dispute that they didn't comply with any, assuming arguendo, it was a franchise agreement in there. They didn't comply with any written disclosure.
That is exactly right. If you look,
it's admitted.
It's admitted. If you look at their interrogatory answers, they say right there, there was no franchise and we gave no franchise disclosures. So, that's our the second point that we want to have this court find, which is, not only was this a franchise, one, number two, they violated the Franchise Act by not giving franchise disclosures and specifically by not disclosing the markup in writing, which was required.
So let me ask you another question. Could the principles of first class have I use a term loosely, a good faith basis to believe that by putting that language in the contract, which is clear and unambiguous, this is not a franchise agreement, that they believe that they weren't doing something to intentionally defraud, like maybe it's a question of fact?
I don't think it's a question of fact, Your Honor. If the question is, it's already a franchise, the Franchise Act requires you to provide these disclosures, whether or not they had a good faith belief that they didn't have to provide these disclosures, it's not relevant to those two questions. If you're going to...
Well, it could be relevant to the issue of whether you're entitled to attorney's fees, because it has to be intentional.
Yeah, well...
So if they believe that, we don't know on this record right now, but it's possible that they may have a different spin on what they were doing.
Well, Your Honor is going to the willful and material prong.
Correct.
So on willfulness, there's no question that, the case law interpreting willfulness says it's just voluntary and intentional as opposed to inadvertent. So the question is, was there non-disclosure, or the method by which they did not disclose the markup, voluntary and intentional, or was it inadvertent? And I think if you look at the facts in the record, and there are no facts coming from the other side, in this case, they discussed in depth with their master franchisor whether and how to disclose the markup. That's at record page 1003. And they also discussed with their own counsel how to disclose the markup, and that's at page 1004. So there's nothing in this record that suggests the decision about whether and how to disclose the markup was simply inadvertent. It was discussed, they discussed it with their lawyers. So that's the willful prong. The material prong, there's no question that a $5 markup is material in this case. If you do the math between $8.50 and $13.50, that's over 37%. So I'll concede the Franchise Act does not give a definition of materiality, but 37% to a business is material under any stretch of the imagination. So the only other point on the Franchise Act I want to highlight is my friend on the other side says that we can't get partial summary judgment because we haven't proven damages. I'll just say, since my time is up, this is partial summary judgment. And if you don't get there under under prong E, you can get there under prong G. Thank you.
Good afternoon, Your Honors. May it please the Court. Matthew Schenker from Fox Rothschild for the respondents. I'll be brief, Your Honors. First, let's talk about the Franchise Act claim. What the motion before the trial court sought, plaintiff's motion, was that there was liability, that they owe damages with the amount to be determined at trial. That's straight from their moving brief. And what appellants ignore in their brief, in their reply, is that they have not attempted to show the court anywhere in the record two things: transaction causation and loss causation. Those things are required not to figure out what the damages are, but to determine whether there's liability. That's from the BMW case. That's from the.
It seems to me that by their allegations that this is really a franchise, no matter what you call it, that first of all, there was transactional liability because you didn't comply with the requirements of the Franchise Act, and in any event, your undisclosed price increase was also a violation separate and apart from that. So I'm having trouble understanding what you mean by saying that they haven't shown liability.
I'm happy to explain that, Judge.
Okay.
Because not only did they have to show that we didn't formally comply with the obligations of the Franchise Act, they have to show, one, that the failure to comply led them to enter into the agreements that they entered into, and two, in other words, that they would not have entered into those agreements had we complied, and two, that the losses that they suffered were a result of the noncompliance with the Franchise Act. That's the Burger Bar case, Judge. In that case, the court said, look, it's not enough to show that you didn't give the franchise disclosures. You have to show that but for that failure, you wouldn't have been here in the first place. You wouldn't have done this deal. And but for the noncompliance with the Franchise Act, you would not have suffered these damages. There's nothing in the record. Not only have they not satisfied their burden of proof, there's no burden of production. So what they asked the court to do is find liability without two key elements. What my adversary says is, well, it's a motion for partial summary judgment. Therefore, we'll leave the damages up to later. No, he's asking for liability. And in order for there to be liability, there has to be causation. There has to be transaction causation and loss causation. It's in the papers. It's in the cases discussed in our briefs. And it's totally absent from the reply brief.
You're not arguing that the Franchise Act doesn't apply, are you? I mean, that sounds like what you're...
We are arguing it based on the El Toro decision. I understand Your Honor disagrees.
Yeah, because that, those talking about waiver of certain provisions of the franchise, this is a complete waiver, right? I mean, so there's
Well,
like,
it
if
doesn't
you
s-
can't waive a small part, how can you say you can waive the entire part?
Just to be clear, Judge, the agreement doesn't say that anything is waived. It says that it's not a franchise.
Yeah, okay.
I understand.
We can argue about the semantics, but
I
it's basically saying no franchise.
I understand. I understand. If I may just briefly talk about
I'm still left with the thought that you can have liability with the trial to address damages later, can't you?
But there has to be a decision on liability first.
That's correct. Like if it's like a rear-end collision, you can establish that fact and later on let the jury determine the damages as a result of the rear-end collision. They're basically seeking partial summary judgment that you're liable under the Franchise Act for failure to disclose, et cetera, that led them to enter into this transaction and not disclose the $5 overcharge, so to speak.
But, Your Honor, there can't be liability without transaction causation and loss causation. That's clear in the cases. The word, if you look at liability and you look at damages, that causation is an element of liability. It's an element of liability. So without the causation, you don't even get to damages. You don't even get to damage. That's why we don't have to look at willful and material. That's why we don't have to look at attorney's fees. Let me just be very brief, Your Honor, Your Honors, and address the fraud claim. I would just point the court again to the Centro Empresarial case, whereby the Court of Appeals held that if you don't even ask the questions that relate to the information that you claim to be relying on, when they say, well, the defendant's business made such and such amount, in reality it made this. These agreements were negotiated by counsel. There's a merger clause. There's nothing in it that speaks to profits or profitability. In the record, all of the plaintiffs admitted, we never asked to see financials. We never asked to see tax returns. The law does not aid someone who does so little to determine information that they later claim induced a fraud.
Who had that information? The tax records and profit and loss statements.
My clients had that.
Client. Was that publicly available?
No, it wasn't.
It wasn't, so they had to get it from your client?
They never asked for it.
Oh, but you were not obligated to turn it over?
No, well, if legally obligated, no. But if the Centro case says, if you don't even ask, you can't be heard to complain later that you were induced by fraud based on some change in facts. And there's a merger clause.
Were these sophisticated investors? Were these people lawyers, accountants?
At least one of them was an accountant, I believe, Your Honor. They were in different walks of life. There were 3 sets of stores and couples, at least one couple, so it's several.
And they were all led to believe that this was a licensing agreement and that everything was hunky-dory because there was not going to be any markup on the gallons of ice cream that were going to be sold to them, and that they were supposed to be making a profit based on whatever information your client provided, and they believed that.
Your Honor.
Because they were either gullible or trustworthy.
They had counsel. They all had counsel that negotiated and negotiated these agreements. And with respect to the statements you're making about the markup, I just have to be clear. This is a disputed issue of fact. They say they were told one thing. We say they were told another thing. And with respect to any statements about profits, the expectations about profits cannot support a fraud claim. These are future-looking statements, and expectations about the profitability of my client's store are relevant if they are using that to project their own profits, which again is not the basis for a fraud claim.
Thank you.
Thank you, Your Honors.
Very briefly, Your Honor. With respect to the loss causation and transaction causation that my friend discussed, they are more than welcome to talk about that with the trial court. They're going to assert there are no damages, we're going to assert there are damages, but that doesn't have any impact on the fact that we can get partial summary judgment on these points here.
I mean, the point is that you're looking to, the first argument is that they threw up as an obstacle to your complaint is that the Franchise Act doesn't apply. You're just trying to get over, and Supreme Court found that there's a factual issue as to whether or not the Franchise Act applies. I mean, that's what it ultimately concludes. You're appealing and saying, no, the Franchise Act does apply. In terms of liability, there's still other issues that have to be resolved when they're talking about the transactional and the other loss issues that would actually make the Franchise Act, that would actually create liability under the Franchise Act. That's not what you're here. No, I'm just saying that we got to get over the first hurdle, and my argument is the Franchise Act applies here. That's it, plain and simple. There's other aspects of it that we got to go through, but I'm not looking at that at this point.
That's correct, Your Honor. We're asking for 4 points on the Franchise Act. A, it applies. B, they failed to provide the written disclosures. C, there's liability for the individual principals because of the points we outlined in our brief. And D, that those violations were willful and material.
Threshold issues, basically, right?
Exactly. There's going to be plenty to talk about at the trial court, but I'm just talking about these 4 points. Briefly, with respect to the dismissal of our fraudulent inducement claim, the other motion by the defendants, the question of whether or not my clients exercised enough, exercised ordinary intelligence when they were being lied to by the defendants, that is at best a question of fact that should be found by the finder of fact after we have our trial.
Thank you.
Thank you, Your Honor. Thank you.